Good morning, everyone, and welcome to what we hope will be the first of many sessions on arbitration in the Caribbean. Today, we will be focusing on reform of Caribbean legislation on arbitration acts using Guyana as a case study. My name is Shan Greer. I am an arbitrator, mediator, and attorney at law, focusing on construction. Today, I am joined by Hans Mahncke and Calvin Hamilton, who I'm going to give an opportunity to introduce themselves.
Hi, good morning. My name is Dr. Hans Mahncke, and I'm an international lawyer as well as an accredited mediator. I have an extensive background in legal education, and I look forward to this session.
Hello, good morning. My name is Calvin Hamilton. I'm an international arbitration practitioner with over 30 years of international arbitration experience. I'm able to practice law in New York and Spain. I also am a member of the International Court of Arbitration of the ICC, and I'm also the chapter chair of the CIARB in Barbados.
Thank you, Hans and Calvin. Today's session, we're going to be looking at 3 points. First, we're going to be looking at some of the challenges experienced when trying to use arbitration within the Caribbean. We're then going to be looking at the model law and for arbitration and looking at how it's relevant and how it provides a guide as to what international practice is. And then lastly, we're going to be looking at Guyana's legislation and how to demonstrate the importance of having up-to-date arbitration acts. Now, we've chosen Guyana because they recently signed a production sharing agreement with Exxon, and it's therefore likely that they will see an influx of foreign investment. And so it's an ideal country to demonstrate some of the challenges that may be experienced if they don't update their legislation, and also a lesson as to why all the other countries should do the same. Now, when we talk about arbitration in the Caribbean, or generally, we want to usually look at the definition of what is arbitration. And what element of that you're going to focus on really depends on what the objective is. If we consider the Caribbean, for traditionally, the dispute resolution procedure normally used are the courts. Over the past 10 to 15 years, we've seen an increase in the use of mediation and arbitration. But arbitration hasn't been capitalized upon in terms of the efficiencies that it can give to providing effective dispute resolution. And so what we want to look today is, why is it that despite the clear benefits that arbitration can give the region, persons are still not using it as they should? Now, when we talk about, as I said, the definition, what we're going to be focusing on is the element of the agreement between parties. Because the clear benefit, or one of the key benefits of arbitration, is something that's referred to as party autonomy, which means that the parties have the freedom to agree all of the elements of their arbitration. And this is a clear benefit because, unlike in the court process, where the court controls how your dispute is resolved, the parties have the flexibility to decide how they're going to decide it. The question, however, arises, well, to what extent do the parties have freedom? Well, it is fairly extensive in the sense that they can decide who will resolve the dispute, the laws that are likely to apply, and the different procedures that they are required to follow that will apply to the arbitration. However, irrespective of the arbitration, there is one key point that no party can get away from, and that is that each arbitration must have an arbitration act that applies to it. And this is because while in the idealist of instances, you would hope that the parties will agree the arbitration and proceed and get a judgment and get an award and it be enforced, there will be instances where what is agreed between the parties is not clear, or one of the parties chooses not to follow the agreement. In those instances, the parties need a regulatory framework in order to enforce the agreement between the parties, or to clarify what that agreement is. And so irrespective of the type of arbitration, the nature of the arbitration, the country in which the arbitration is going to take place, all arbitrations must have an arbitration act that guides them. And that's normally called the seat of the arbitration. Now, you can choose a wide variety of countries for your seat, and the extent to which you will choose one depends on the key elements that help support the arbitration. So we're first going to look at what are the key elements that you require for an arbitration to be successful. Now, I spoke about the need for a good legislative framework, which is what we're going to be talking about today. But I also want to touch on some of the other elements which are also important and which will form the subject matter of other webinars that we're going to be hosting in the future. So the first is an adequately and appropriately drafted arbitration clause. For arbitration to be successful, since it's an agreement between the parties have to know what the agreement is. It is not uncommon in the Caribbean for persons to have clauses like any dispute arising between the parties shall be resolved by arbitration. And while technically that is an enforceable arbitration clause, it is not an efficient one. It doesn't provide any guidance as to how that arbitration will be administered and what are the elements that are agreed. And because of that, you will find that very often the parties will get into arguments over what the arbitration agreement means when they actually start to proceed with it. The second is an appreciation of the process by counsel and the parties. It's one thing to agree to go to arbitration, it's another thing to have an understanding as to what arbitration is. It's not uncommon in the Caribbean to have a lot of arbitrations operate as if they are court proceedings outside of court. And while there's theoretically no reason why you can't do it that way, there are disadvantages to doing that way, and failing to do so means that you don't capitalize on the benefits of arbitration because you don't understand the process. Arbitrations need good administrative support. You have to have adequate conference rooms, hotels, especially if you want to attract international arbitrations, as well as stenographers. So it's important to have all of those available as well. Can I just ask everyone to mute their mic so we don't have any backdrop? Thank you. The next is an effective and efficient arbitral tribunal. You have to have persons who have the necessary competencies in arbitration. And very often, counsel tends to focus on, does this person have the technical expertise? Do they know construction? Do they know insurance? But in addition to their technical expertise, the arbitrator or potential arbitrator should also have experience in arbitration or understand the process. Because if you don't follow the arbitral process, which is an issue that we'll be looking at a little later in the webinar, you can have an award set aside, even if the award is technically sound. So this is a critical issue. And very often, parties don't just have to, as the old adage goes, have justice done, but it has to be seen to be done. And if you have an arbitration that isn't administered effectively, the parties may leave the process feeling that justice wasn't done. And that's something that we need to keep in mind. Otherwise, persons won't come back to the process. We have to have necessary rules. The parties have to know how they're going to administer the process. When are you going to file witness statements? What evidence rules apply? Issues such as those have to be dealt with. Practically, to deal with those on the cuff normally causes a lot of confusion. And so very often parties will pick a specific set of rules. Within the region, over the past 5 years, we've had the establishment of quite a few arbitration centers, and all of them have fairly comprehensive rules that can be relied upon. So that's one area where we have seen substantive development in the Caribbean over the years. Lastly, but certainly by no means not important, is of course the ability to enforce. There are a few countries in the Caribbean, St. Lucia, the island I'm from being one of them, who are not signatories to the New York Convention. And of course, if you're not a signatory to that convention, I believe Hans will be talking about that a little later, it can create challenges for the arbitration. So the last issue we're going to be talking about is the good legislative framework. So the framework is the Arbitration Act that's going to apply, and that's what we're going to be focusing on for this session. So I'm now going to look at what do you need in an arbitration act in order for you to effectively assist in having an effective arbitration. And the first is a definition of arbitration that is sufficiently wide for the use of arbitration both domestically and within the international business community. That's very important because technology has moved us from the time of yesteryear where transactions were done by letters. And so you need an arbitration act that takes into account the way that we do business in the 20th century. Second, you need to ensure that the parties maintain control over key elements of the arbitration process. So they have to allow the parties the opportunity to agree. If you want to have a party autonomy, the parties have to have that power. So you have to ensure that the act gives the parties that power. It also has to give the tribunal the necessary powers to be able to administer the process in a fair way. And lastly, but certainly also more importantly, is to give the court the power to supervise and support the process. So in instances where parties do not comply or are failing to follow what was agreed, that the court is in the position to compel them to do so. Now, when we talk about the Caribbean, given the critical nature of the law of the seat, it's important for us to move with the times and have arbitration acts that reflect international practice. Now, there are some countries who have done that. BVI, Jamaica, Cayman Islands, Bahamas, and Barbados have all updated their acts to make it consistent with the model law, which Hans will be speaking about in after my element of the presentation. But quite a few of the Commonwealth Caribbean Islands have outdated acts, some the 1889 and some the 1950 British Act. And as countries that rely heavily on foreign investment, not having arbitration acts that are effective can cause a real problem. By way of example, the World Bank produces every year an ease of doing business report, where they rank 190 countries on how well you're able to facilitate business in your country. Within the Caribbean, the highest ranking country is Jamaica. You'll note one of the countries that have updated legislation, and they're ranked as 75. Guyana, who has the 1889 British Act, is 134. Now, one of the indicators that is used to rank these countries is the ability to enforce contracts and how effective that is. Now, Jamaica ranked 50.5 on that indicator, whereas Guyana ranked 27. So what you see here is an effective arbitration act is not the only factor that they take into account. There's several, but certainly in helping you have a more efficient administration of justice and to help the courts work better, arbitration can play a key role. So having an updated arbitration act makes a difference. So let's look at some of the reasons why these particular the 1889 and 1950 Act are not effective. Well, the first is they tend to not have default positions. So whereas on more updated arbitration acts, they would say, if the parties don't agree, this is what happens. So in instances where there isn't that agreement, where there is this clause which says any dispute arising will go to arbitration, the parties have a default that they can go to. The 1889 and 1950 Act, they don't deal with all of the issues. So there isn't a default position for determining the seat of the arbitration, about the rules, about the laws of the arbitration. And these are important if you want to ensure that in instances where there isn't a very effectively drafted arbitration agreement, that the law provides a way for the arbitration to still be effective. The next is conflicting laws. Not only do you have to have a good arbitration act, but you have to ensure that your other legislation don't conflict with it. So by way of example, both in St. Lucia and Trinidad, we have evidence acts which say that arbitrations are bound by the rules of evidence. That means that rules relating to hearsay, for example, would apply to arbitrations. And for the most part, one of the benefits of having arbitration is to get away from these strict evidential rules. So if the parties don't expressly exclude that, they may find themselves bound by rules that not realizing they were bound by them, and it may have adverse effects on the effectiveness of the arbitration. And lastly, it's the issue of what's considered misconduct. Under both the 1889 and 1950 Act, an arbitration award can be set aside if the arbitrator misconducts himself. Now, the acts themselves do not define what misconduct is, and that means that the court has to look at the circumstances and come up with and use its discretion to decide in what instances an arbitrator has misconducted themselves. Initially, under the law, there were 4 clear grounds on which an award could be set aside. And over the years, the courts have eroded it, and there have been several grounds. And I think if you want an example of where we are with respect to misconduct, a good case to have a look at is NH International Caribbean versus NIPRO. That case actually went to the Privy Council, and you can find it online. It's a Trinidadian case. And what you'll notice in that case is in the Court of Appeal, Justice Bureau did a fairly thorough review of all of the cases relating to misconduct. And what he showed was the variances in approaches by the different courts and the different judges. And what he said is, look, there are different approaches here, and I'm choosing this particular one, but there isn't that level of clarity. Whereas with updated acts, you'll find that you are fairly clear as to the grounds because they're normally listed. And if your ground is not listed, then it cannot be considered. So having looked at some of the issues with respect to arbitration, I'm now going to hand over to Hans, who's going to talk about arbitration, the model law, and what the international standard is, so we know what we're striving to. Hans?
Thanks, Shan. Thanks very much. So I'll talk a bit about the UNCITRAL model law, which is a law that was adopted in 1985. And it was adopted by the United Nations Commission on International Trade Law, hence the acronym UNCITRAL. Let's see if we can move this forward. All right. So before we get to the UNCITRAL model law, let's look at some of the history here. So I said 1985 is when this model law was adopted. We have to sort of go back in time a bit to look at where this came from. And I think from what Shan was telling us, we've already realized and we can see how conceptually, for any arbitration regime to work, we really need 2 main things in place. And this is where this 1958 New York Convention comes in. What we need when we have any arbitration regime is we need to ensure that the arbitration regime runs separately from the normal court system, because otherwise what's the point of having arbitration? So you go through arbitration and whoever loses and they don't like that, then they just go to the normal court system. Well, that's no good. So whatever happens for any functional arbitration system, we need to ensure that that does not happen. The other thing conceptually that we need, of course, and Shan already alluded to this, is we need enforcement. So if we win our arbitration and we get an award, can we enforce it not only in the country where the arbitration takes place, which could be any random country, but wherever the other party is located, for instance, or where the other party has assets. So these are the 2 mainstays of any international arbitration regime for it to be able to work. And of course, this has been recognized for a long time. And even before 1958, it was just that in 1958, things came together under the auspices of the UN. And so the New York Convention sets out these key foundations, which are the 2 I just mentioned, as well as various other things. But those are really the two mainstays. And as we went forward from 1958, of course, we also saw that there was a divergence of national laws regulating arbitration. And one of the problems you have is you might have a national arbitration law, and then you might have an international one. And if they're the same, then you have problems. For instance, as Shan mentioned, you might have problems with rules of evidence. Another big problem is in terms of the domestic arbitration regimes is they might only allow domestic arbitrators to participate, or even domestic lawyers. So how do we stop that? Well, we need different laws. We need international laws that are more in tune with international disputes. So the UNCITRAL model law, as I mentioned, 1985 is when it came into force. It drew on the experiences that other countries had gone through. Switzerland, France, United Kingdom, they had all modernized their own arbitration laws to make them more compatible with the international setting. And once it came about in 1985, and it's been revised, and we'll get to that in a moment, but 1985 is when it first came about, we could look at some of the key features or excerpts of the UNCITRAL model law. So first of all, as the name model suggests, it is just a model law. It is not binding. You can adapt it. So it's a model law. You can have a look at it. It's on the UN's website, and you don't have to transcribe it into your own national jurisdiction one for one. What you can do is you can look at it, you can transcribe it, but you can also amend it. You can add things, you can change things. That's the whole point of a model law. I think we've gone back a slide here. Can we go? Oh, thanks very much. Now, it applies to international commercial disputes. The model law lists a whole list of examples of what those might be, but it can go beyond that too. Again, it's a model law, so countries can adapt that to their own needs. It applies if the arbitration takes place in the state where the law was adopted. So in other words, wherever the arbitration takes place, you need to have this law in place. And again, as I said earlier, that is to ensure both that the arbitration takes precedence over the national courts, very important, and number two, that once there is an award, it is enforceable in all the member countries. So the role of national courts is very limited. That's set out in the model law. Again, very, very important, because what's the point in arbitrating if once you win or you lose, you can just go to the national courts and redo the whole process. Then there's no point in arbitrating. So it's very important to limit that role, and the model law sets out how the role is limited. There's different options for the arbitration agreement. So but does it have to be in writing? Does it have to be evidenced in writing? There's been some amendments more recently on this, because of course nowadays in the digital age, you have things done online, you have digital signatures, there's so much going on, and that is also reflected in the model law. The arbitrators are appointed according to whatever the parties agree, so usually that would be 3, but again, parties are free to agree whatever they like, and the model law takes account of that. The parties can also agree whatever procedure is to be followed, and the tribunal, this is something that's become more important recently, has the power to order interim measures. So while the proceedings are going on, there may be interim measures, and the model law speaks to those as well. And generally speaking, it's similar to the adversarial system that we know of, especially in the common law countries. So parties have a right to be heard, parties have a right to examine witnesses, all the usual rules, that's all set out in the model law as well. The awards can be enforced, as we mentioned, in any signatory country, which is part of the beauty of arbitration, so that so you have a company from country A and a company from country B, and they're in a dispute, and they go to arbitration, and the arbitration takes place, say, in country C. So you've got 3 different countries involved. But so long as the award is enforced in a member country, it's enforceable, because that's what the model law says, and that takes us all the way back to the New York Convention as well. Now, apart from the model law, there's also UNCITRAL also has something called the arbitration rules. And those are basically for ad hoc arbitrations where the parties have not agreed on a particular institution, on a particular set of rules, on a particular way of appointing arbitrators, all the things we just discussed. So what if parties have been a bit sloppy in their own agreement? What if they just said, if there's a dispute, we go to arbitration, but they haven't really provided any further details? Well, for those cases, UNCITRAL offers these arbitration rules, which can then be used in those kinds of ad hoc circumstances. And as of 2017, 104 jurisdictions have adopted legislation based on the model law. All right, well, that's a quick overview of the UNCITRAL model law. We'll now go over to Calvin and have a look at Guyana.
Thank you, Hans. Thank you, Shan. as Hans indicated, I'm going to look at a country specific, Guyana, to discuss some of what has already been mentioned. One of the things that has been mentioned is the need to harmonize and improve domestic laws in the region. And essentially, the need to do so has been determined by a number of findings, two of which are A, the domestic laws are often inappropriate for international cases. International practice require a number of different things that you wouldn't see in the law. Can you go back? Yes, okay. Inappropriate. So domestic laws are often inappropriate. There is also, and in particular with our region, where we're looking for a certain amount of uniformity, not only of case law, but of jurisprudence, the differences of the different laws in each of the jurisdictions provides a disparity among the various jurisdictions, so that the courts interpreting their particular laws may arrive at different decisions, which would mean that there is a disparity with respect to harmonization in the region. By way of example, domestic laws are often outdated. We mentioned Guyana's, Trinidad's is also outdated. There is language in those legislations which are at variance, at best, with international arbitration practice. The legislation could be fragmentary in that they do not address all relevant developments in modern arbitration practice. Negative consequences could derive therefrom, in that traditional local concepts are imposed on international cases, and as a result, the need of modern practice are therefore not met. And I pause there just to give an example. Just suppose in international arbitration practice, there are no obstacles placed for foreign lawyers, foreign arbitrators to conduct an arbitration in a particular jurisdiction where modern arbitration practice is the order of the day. For example, in Paris, London, New York, Switzerland, Geneva, they do not place any obstacles with respect to who can conduct international arbitration in their territory. If you look to the laws of many of the in our region, they require that, or they understand that the practice of international arbitration in that jurisdiction will be considered the practice of law. And as a result, there are bar association considerations to be met. So that's what I meant by the negative consequences as they relate to international arbitration practice. Can I have the next slide? So there's a frustration when you have these mandatory provisions of the applicable outdated law. For example, other examples would be parties' ability to effectively submit future disputes to arbitration, parties' power to select the arbitrator freely, or parties interested in having the arbitral proceedings conducted according to the agreed rules and procedures, the rules and procedures being agreed to by the parties. Shan mentioned the parties' autonomy to be able to do that. Use of archaic terminology, I mentioned that previously. A good example would be in the Guyana law, they use submission to refer to the arbitration agreement. Now, in international arbitration practice, submission may mean something else. The New York Convention, which Hans talked to or spoke to just a few minutes ago, and as is one of the pillars for international arbitration practice, refers to the arbitration agreement. The submission would be, for example, to submit to arbitration after the dispute has arisen. And as a result of that, the use of submission in, for example, the Guyana Arbitration Act may create some confusion to the unwary. The next slide, please. So a party may well, for some of those reasons that I just mentioned, hesitate or refuse to agree to place an arbitration in a particular jurisdiction in our region. Shan mentioned the significance of the seat, so that if you do not have a friendly arbitration law, a modern arbitration law, then parties are reluctant to place or use as a seat that particular jurisdiction. What does that do? Then it reduces the possible places of arbitration in the region where international arbitration could be conducted. Why? Because states want legislation that's easily recognizable. They want legislation that comply with specific needs of international commercial arbitration. They want an international standard. They want something that they can recognize. Just suppose, and I think Hans used an example of nationals from state A and state B. Now, the last thing they want is to go to courts, so they choose arbitration. If they choose arbitration, then they have to seat the arbitration someplace. So they decide to seat it in Guyana. Well, Guyana's laws aren't familiar to states A and nationals of states A and state B. So there may be a problem for nationals of state A and state B to want to seat an arbitration there. Whereas if state C, which is where the arbitration is seated, has modern arbitration legislation, then the parties, without knowing particulars about state C, would recognize immediately that it's an arbitration-friendly jurisdiction, that there are international standards, that the courts in that jurisdiction would recognize those arbitration international standards, and as a result, there would be less of a reluctance to go to that seat to conduct the arbitration. The next slide, please. So what are salient features of international arbitration practice, international modern arbitration legislation that are absent in the Guyana Act? There are a number of them. I'll deal with them just superficially, but I'll hang around on one or two of them. One of them is special procedural regime for modern international commercial arbitration. What is that regime? What's the scope of the application of the legislation? That's missing in the Guyana Arbitration Act. Also missing in the Guyana Arbitration Act is the regulation of the arbitration agreement, the definition, what form constitutes the arbitration agreement. Shan, I think, mentioned that in past years, the form or the way to do business has evolved. It's no longer necessary in modern arbitration practice that you have a formal letter or agreement to conduct a form that would constitute a form of agreement. An exchange of emails, for example, could constitute an agreement to arbitrate. What are the conditions that would disallow a court from intervening prematurely in an arbitration? Can those requirements be included in an arbitration agreement? Interim measures, Hans mentioned this. So this regulation of an arbitration agreement is absent in the Guyana legislation. Next slide. The regulation, the composition of the tribunal. How do you go about composing a tribunal if the parties have failed to reach agreement on that? That is also missing. Or regulation of the jurisdiction of the arbitration tribunal. Now, this is important. Just imagine if we have an arbitration, the parties have agreed in the event of a dispute to go to arbitration. When the dispute arises, one of the parties is recalcitrant, wants to frustrate it, doesn't feel good about his possibilities or her possibilities about prevailing on the merits in the arbitration. That party can allege there's been fraud in the inducement, for example, of the contract, or any other such allegation that would put into question the legitimacy of the contract. Of course, what happens then would be that the parties need to go to courts. Courts then need to determine whether or not this contract is valid, and only then would the tribunal, the arbitration, be able to continue. Now, that takes a lot of time, and the mere reason for going to arbitration was to avoid an undue influence or intervention of the courts. So the system, modern international arbitration, had to do something about a situation such as I just described. And they've come up with this concept called competence, which in effect means that the arbitrators can determine their own jurisdiction. Now, for them to do that, there need to be an additional concept, which is the separability. In other words, when you sign a contract, you include an arbitration clause. That arbitration clause is considered a separate contract from the main agreement. That's the separability. It allows the arbitrators, therefore, to make a determination with respect to those allegations as to whether or not the contract is fraudulent or not. This way, the arbitration is not delayed. It can go forward, even though the parties may go to courts to seek a determination as to the fraudulent nature of the contract. The court obviously has a final say, but what we have achieved or accomplished by this methodology is that the arbitration is not delayed, and that's a good thing. Also missing would be the regulation of the conduct of the arbitration proceedings per se. That is something that needs to be developed. Next slide. The making of the award and determination of the proceedings. That's not developed in the Guyana Arbitration Act, nor is the recourse against the award in the event that there has been a breach of due process. What can parties do? Now, the courts can step in to hear allegations about setting aside the award. The court will not determine the merits, but rather or not whether or not the procedures were conducted fairly. And finally, recognition and enforcement of the awards. The courts will need to determine whether or not a request for recognition and reformance reach or meet the legislation, or in the case of those jurisdictions that have signed the New York Convention, whether they meet the requirements. Next slide. So as a general comment, I would say that the Guyana Arbitration Act, because of the lack of these salient features that I just mentioned, you would have a situation where the courts become involved in almost every aspect of the arbitration process, and this to the detriment of party autonomy. Obviously, the reason this will be so is because this act is an adoption of one of the old English Arbitration Acts and has not been updated ever since enactment. I would suggest also that the English Arbitration Act has now been remodeled. We've now got the 1996, I think, English Arbitration Act, which recognizes that courts have their place, or it recognizes also party autonomy. Next slide. I think Shan, I think Shan mentioned that there is a lot of commercial activity going on in Guyana right now, and one of the drivers of those activities is the recent signing of the petroleum agreement between Guyana, ESSO, and a number of other Hess, and I think Nexen recently. What I wanted to mention with respect to that agreement is that that agreement has a clause that the parties are obliged to resolve matters by alternative dispute mechanism process, so that Article 26 has the dispute resolution provisions. 26.1 provides that the parties are obliged to seek an amicable settlement to any dispute that arises. So a first tier established in Article 26 is that the parties need to try to negotiate their differences. In the event that they're unable to do so, then Article 26, Article, I think, 26.2, can we get to the next slide? Article 26.2 provides that in the event the parties fail to reach an amicable settlement, then they would go to arbitration. Now, the clause in 26.2 is a very interesting clause. It obviously reflects very good knowledge and understanding of the international arbitration process. Because as Shan pointed out, I think in one of her comments, you need a comprehensive agreement to exclude or to avoid litigation over the clause itself. You don't want to have an arbitration clause. You don't want to have the expectations of going to arbitration only to be struck with the need to go to courts to make a determination as to the interpretation of that clause. So if we take some time to look at this clause, it says any claim, demand, cause of action, dispute or controversy, which is quite broad, arising out of, which is from out of the actual agreement, or in connection with, let's say you have another agreement and there's a right of set-off. Can you use that right of set-off in the dispute here under the petroleum agreement? But you might be able to, because this language says in connection with, in connection with this agreement, including any question regarding formation. Is the clause valid? Remember, we talked about a fraudulent contract. So here, this clause says we can make a determination. The tribunal, the arbitration tribunal, can make determinations as to the formation, the very existence of the arbitration clause, its validity, enforceability, performance, termination, or alleged breach. Any of those issues can be settled by arbitration. The point here being that international arbitration practice prevails when Guyana and Exxon came about to strike an agreement with respect to the exploration. They decided any dispute arising should be settled by arbitration. So it shows that there is a modern approach in Guyana to understand that arbitration is a proper vehicle. What we need to do now is get Guyana's laws up to speed with that understanding. Next slide, please. Article 26.4 provides that any disputes are subject to arbitration, and the disputes would be subject to administration by an entity called ICSID. ICSID is a facility of the World Bank, and what ICSID is about is investors and states can resolve their dispute using the ICSID mechanism, the ICSID rules. The seat of the arbitration would be in Washington, D.C. Again, what this is, it's a modern approach to international arbitration, and again, Guyana has opted for a modern approach to resolution of the disputes. The seat of the arbitration is in Washington, D.C. But I just want to make one special mention here in Article 26.4. The clause also says that in the event that ICSID, the facility from the World Bank, is unable to register that request for arbitration for whatever reason, and there are a number of reasons, number of requirements that must be met before ICSID will decide to allow their platform to be used to administer the arbitration. In the event that one of those requirements might not be met, the parties insisting again that they want arbitration have decided they will use UNCITRAL rules. Hans mentioned that UNCITRAL rules and administered by the AAA, which is an institution in the United States, to resolve any disputes. Again, a reconfirmation of the fact that the parties want to resolve their dispute by arbitration. So here, the message is courts are excluded, whichever way you look at it. As long as a dispute arises, whenever that dispute arises, you go to arbitration, albeit ICSID or using the UNCITRAL rules under the AAA administration. Next slide. The applicable laws to govern this petroleum agreement, the laws of Guyana, are the laws that are applicable. However, if Guyana's laws are inconsistent with rules of international law, as may be applicable and appropriate, or customs, usages, and trade practices of the international petroleum industry, then of course, Guyana's laws will be superseded by those principles, international law principles, customs, uses, and trade. So that in effect, while Guyana's laws are the applicable laws, only when they are consistent with international arbitration, international legislation, international law, international customs usage, and the trade practices of the international petroleum industry. And that concludes my presentation, and I think we have agreed to take a few questions, and I'll turn this over to Shan. You might want to put on you're muted, Shan.
Yes, thank you, Calvin. We're going to be taking some questions. What I'll ask you to, if you look at the bottom of your screen, you'll see an icon that says Q&A. And if you click on that, you'll be able to, it'll allow you to type your questions in. We'll just give you a few minutes to do that, and then we will take the questions. Okay, we seem to have quite a few questions. We're not going to have time to deal with all of them. However, what we may do is have another Q&A session, and we'll provide the slides and then just have a question and answer session so that we'll be able to address all of the questions persons have. But I'm just going to take some of the ones that have arisen. So the first is, does the model law take into account country-specific peculiarities?
Maybe I can make a start there. It does, and it should. So, for instance, if you look at the Bahamas, they have a very strong history in the maritime sector. So, of course, their law would reflect that. And in fact, if you look at some of the recent events in the Bahamas, they're trying very hard to develop the Bahamas into an arbitration hub, and in particular, with a focus not only on maritime, even though that's very big, but also construction. So there's features, and I guess we can't get into the details here, but those sectors will have particular issues, particular things. For instance, the interim measures that we talked about, very important in construction.
Right.
So those model laws, of course, can reflect that. In the case of Bahamas, for instance, they would, but in case of any other country in the Caribbean, they would as well. So absolutely, I think the answer is yes.
Yeah. I think
go ahead.
I think as well, we want to also take into account that the industry moves very swiftly, and very often the model law may not take into account recent developments. So by way of example, the BVI Act has a provision which states that any court proceedings for arbitration is confidential. So not only do you have confidentiality in the arbitration proceedings, you also have confidentiality if any of the matters are referred to court. For example, if you want to challenge your award or appoint an arbitrator, or any of the other ways in which the court supervises the process. So in addition to the model law, essentially just this is the nuts and bolts. But we don't want countries to not continue to be innovative. So if there are specific things that will make the process more effectively, certainly you want to include those. And I think BVI has done an excellent job in doing that.
I would just add to that the model law has been developed by a number of practitioners coming together on the UNCITRAL that Hans mentioned, from different jurisdictions and different legal traditions. And they've come together to come up with this law so that there is, as immediately you have a uniformity of application of international arbitration practice present in the law. There is also courts interpret the model law uniformly around the world, so that there is a body of jurisprudence that can be accessed if you, in China, for example, wanted to see how a particular provision can be interpreted. You have this body of jurisprudence that's readily available to you to be able to understand how that works, so that it makes it easy for anybody who can be subject to the application of a model law jurisdiction to understand how that jurisdiction will interpret that provision.
Thank you, Calvin. The next question is, should the Caribbean take a unified approach to arbitration law reform? Sure, go ahead.
Go ahead. No, I was going to say, well, that sort of picks up on what I just mentioned about having uniform jurisprudence, and then of course it's easy to because we've our whole idea of integration, CARICOM and the likes. I think it behooves us to want to have a uniform approach. It also allows us to seat arbitrations in a particular jurisdiction without concern for another jurisdiction's legislation which may be at variance. But we also have a particular circumstance in the Caribbean at the moment, and that is the CCJ as an appellate body. Only 4 countries have signed on to the CCJ at the moment. The others still resort to the Privy Council. Now, it's most likely, if the CCJ is interpreting and is following international arbitration practice, that it would be consistent with the Privy Council's interpretation of international arbitration provisions. However, there is a certain amount of uncertainty still present, and until and on such time that all the jurisdictions adhere, if that ever comes to pass, the CCJ as the appellate body, we still have this threat of an inconsistent interpretation of a particular provision.
Yeah, I think in idealist of circumstances, it would make more sense for all of the countries to take a unified approach. Realistically, however, we've had some countries already change their laws. So I don't know to what extent we will have uniformity across the board in terms of all the countries having the exact same legislation. However, I think at this stage, the more important issue is to at least have all the countries have updated arbitration acts. I think that's by far more critical. And I know that the Impact Justice has produced a draft a model arbitration act for the Caribbean, which is currently being considered. And that certainly is a good step forward for countries who have not updated their laws, at least to have that as a starting point. All the countries will not have exact arbitration acts because they're going to have specific peculiarities that apply to their country, but certainly having all the countries with a modern act would be our place of our port of first call. And then after that, we can look at how we can harmonize them and extent to which that will make sense.
Well, I think the harmony, in the event that you don't have identical arbitration acts, and in fact, France is different to England's, is different to Spain's, is different to Switzerland's, but they all have one thing in common. They have incorporated in the legislation, regardless of however they articulate it, they have all incorporated modern arbitration practice as understood and interpreted by the various modern arbitration jurisdictions around the world. So yes, of course, we have the pleasure and the leisure of having different acts, if different acts means that you have different articulation of clauses. But I think the principles, the pillars of international arbitration practice must be present in each and every one of them.
Thank you. Okay, so the last question we'll take, because our time only allows one more, is what is the role of the courts in facilitating arbitration?
Oh, maybe I'll make a start on that one. It's very important for members of the judiciary to appreciate their role in arbitration. And culturally, that's quite a shift from what a lot of people would be used to in the judiciary, especially where in countries where perhaps arbitration isn't as developed as elsewhere. I recall there's an infamous case from in Barbados. It goes sort of 20, 30 years back, to do with their airport when that was all being redone, and there was a contractor, and that went to arbitration. Because the courts in that circumstance may not have kind of had fully appreciated the role, they kept intervening, or perhaps one of the parties was sort of quite pushy in getting it to intervene. But the end result was that the contractor went bankrupt while all this was going on. So I think it's very, very important from a cultural point of view to understand that arbitration is something that needs to run more or less without interference from the courts. And even though this is what I call it interference, it is well meant. I'm not saying that there's sort of anything untoward going on. It's just disruptive to the idea and the system of arbitration having it. So we need to have sort of clearly delineated areas, sort of this is the arbitration and the courts only have this sort of very limited role here. And that's something that of course takes time to sort of get and understand. And there's various countries, if you look at Asia, where there's a lot of training programs for the members of the judiciary to sort of impart that sort of idea. So very good question. I think very, very important to clearly delineate those roles, because once you have courts that intervene, and again, I'm not saying there's sort of anything bad going on, it's just sort of culturally, if a court sees itself in the role of judging these things, and has done so for decades, then it's very difficult to sort of appreciate that, well, we shouldn't intervene because this is a separate thing. But where it does happen, of course, that country then gets a bad reputation, and people wouldn't want to conduct their arbitrations there because they know they'll get held up, things will get held up in the national courts, and so that's no good.
And I think that's an excellent point, Hans, because I know that the recent CCJ decision of Belize Bank, government of Belize versus Belize Bank, where they did not enforce an award. And that gave the perception that the Caribbean is not a arbitration-friendly jurisdiction. And in fact, if you look at the decisions in the various countries, you'll find that in many instances, the courts will enforce awards, and they do take a very arbitration-friendly approach, to the extent that their laws permit them to do so. Because of course, if there's a misconduct issue, they cannot not implement whatever relevant laws exist in that country. But to the extent that their laws allow them to do so, you will find that generally in the Caribbean, judges are willing to respect the process. We've also, with the Chartered Institute of Arbitrators, the Caribbean branch, we've done a lot of work, including working with the judges. We've held a few seminars where we have provided some information about how the process works so they can understand what their role is and they can better appreciate how they get involved in the process. So I think when it comes to judges, we are making very good strides in having them understand and support the process.
I think the Caribbean doesn't have the exclusivity of judges, the judiciary misunderstanding its role initially in the advent of the development of arbitration. If you go to Latin America, you go to Europe, you go to Africa, a lot of these places, there's always been this jealousy, animosity and protection, the need to protect turf, if you will, between the two jurisdictions. Fortunately, they come around to understanding that they each needs the other. Arbitration will not be successful without the court's role as the keeper, the gatekeeper, to ensure that due process is conducted and is meted out to the parties. The courts play that role. They're the ultimate guarantor of the integrity of the arbitration process, and they intervene and should intervene only when that integrity is threatened. Apart from that, they should stay out of it, and that is the learning process, I think, for judges. I think, and again, the judiciary and the underlying premise here is the autonomy of the arbitration, the autonomy of the parties to be able to determine how they want to settle their disputes. And once the legislation allows parties to exercise that autonomy, then of course the judges, the courts have to respect that, even though if they were to review this, they may arrive at something different on the merits. They need to restrain their enthusiasm in favor of the autonomy of the parties. And just with respect to the reference to the Belize case, the court, although we can debate whether or not the CCJ got it right with respect to that decision not to recognize the recognition and enforcement of the award. I think with respect to the process, they based their decision not to recognize it on a question public policy, and which is something that's permitted under the few exceptions as to when the courts can become involved in a petition for recognition and enforcement. And so they use this public policy issue to reach the decision that they reached. Now we can debate whether or not they got it right or they didn't get it right, but essentially that's what they do. That's what they did. And this public policy thing has always created problems for many courts because it's not defined as to what should be public policy for all aspects of these issues. But again, just to say that the CCJ, what they used was the public policy requirement with respect to recognition and enforcement.
Thank you. Thank you everyone for your questions. As I said, there are quite a few here and we're not going to be able to get through them all. However, we promise we will do another Q&A session and we'll provide you with that information at a later date. I would like to thank you all for attending and also to thank my fellow presenters, Calvin and Hans. And
Pleasure.
we look forward to—
Thank you.
You're welcome. And we look forward to doing more webinars on the topics related to arbitration in the Caribbean. Thank you very much.
Thank you. Thank you very much. Thanks.